All right, hello and welcome to Quadcast, Quadrant Chamber's regular discussion forum. And we have a shipping special this week, so we're going to be talking about arrest and Admiralty Court in rem procedure. My name is Paul Henton. I'm joined by, in no particular order, Steph Barrett.
Hi.
Ben Joseph.
Morning.
Hello. And Emmet Coldrick.
Hello.
And we are four barristers from Quadrant Chambers. And one thing we've all got in common is we've all got quite a bit of first-hand recent experience of this particular area. And I think we'd probably all agree that we've seen a bit of an uptick in instructions to bring or resist or participate in arrest proceedings during the recent pandemic. And I think it's probably that's a feature of economic downturns. You tend to see more instructions in moravian injunctions and insolvency type process and things like that, and arrest process. So this week we're going to be sharing some of our recent experiences. We're going to be looking at the recent cases of the Columbus and the Vasco da Gama, which is ongoing litigation in which I think at least three of us, maybe all four of us, have been involved. It's given rise to 3 reported judgments so far, and we're going to be focusing on just those aspects of the case which have been decided finally and unappealably. So anything that's still open will stay off those topics, insofar as we might all have different views on those. We're going to be looking at things from the perspective of protagonists in this type of litigation. So key categories of in rem claimants, so banks, crew, ports, bunker suppliers, and so on. We're also going to look at issues of timing and practical issues in terms of when do I bring my claim in rem against a vessel, how do I do it, what's the procedure. I know that a lot of our audience will be pretty familiar with the procedure, but we've also got a big international audience as well. So we're going to be talking a little bit about that as well. There's a Q&A function, so we do encourage those who've joined us live to get involved, put any questions in the Q&A or the chat on this Zoom call, and we will get to those if we can, because we really appreciate having people here live. We know that some people are going to watch it again on YouTube, but this is your opportunity to fire questions at the panel, and we'll try and deal with them in real time. So I think to kick things off, we need to just quickly have a quick summary of the English Admiralty Court in rem procedure. So I'm going to ask Ben to give us that, if you don't mind, Ben.
Happy to, Paul. But just broadly, because there will be a variety of experience, many people on this talk would have actually participated in the case and need no explanation. But in terms of Admiralty 101, the Admiralty Court is a division of the High Court of Justice. And in summary, there are 2 key types of jurisdiction of the court. The first are in rem claims, which are claims brought against specific vessels. And the second type of jurisdiction is in personam claims, which involve cases of collision or limitation of damage or breach of the merchant shipping regulations. And the discussion today is mostly focused, or entirely focused, on that first head of jurisdiction, claims against vessels. There are 3 types of claims against vessels. The first are proprietary claims, such as claims for possession by a mortgagee. The second type are maritime liens, which are a very narrow category of historically permitted Admiralty claims. And those claims will bind even a bona fide future purchaser of a vessel. And those include claims by salvagors, claims for crew wages, claims by a master for his wages and disbursements. The third and final type of claim are statutory liens, which are a much broader category of claims, and we'll be discussing some of those today, but they include matters such as claims for goods and services provided to a vessel.
Okay, yeah, so what we're looking at is when can I bring my claim against the ship? So you bring arrest proceedings, perhaps in a situation where the operators of the vessel might be impecunious. You might want to go against the ship instead. and we're going to look at the process whereby the vessel is arrested, perhaps ordered to be sold by the Admiralty Court with the proceeds paid into court, and the various creditors having an opportunity to submit their claims against the proceeds of sale and perhaps be paid out a percentage recovery, perhaps not always 100% of their claim, but maybe more than you might get if you're going against the impecunious operator. So
yeah, and if I could just jump in there on the insolvency angle. So as Paul said, very often you're dealing with a ship owner who's impecunious or indeed insolvent, and if there are insolvency proceedings underway, you will be sent off by the Admiralty Court to the company's court to get permission before you can continue your in rem claim. In practice, that's usually, but one can't say invariably, but usually a matter of routine. You will be given permission. And one of the interesting aspects of the in rem jurisdiction, the Admiralty jurisdiction in rem, from an insolvency practitioner's point of view, is that the order of priority of distribution of the proceeds of a sale of a ship by the Admiralty Court isn't the same as the order of priority that would apply if it was just a liquidation. So, for example, in a ordinary insolvency situation, a liquidation, the holders of a fixed charge will come at the very top. But as I'm sure we'll come on to, that's not the case in Admiralty proceedings in rem. And that's certainly an angle that we'll have to bear in mind, I think, as we look at the different creditors and their position.
Yeah, absolutely. I think a lot of us have been in that situation where you're instructed by the bank, and the bank says, "Well, I want to put in a receiver. I want to recover my money." And part of the focus of what we're looking at today is really the different types of creditor who the bank might be surprised to learn may have super priority or rights in priority to their own, or at least whose rights need to be taken into account before or during the sale process, or before the court will make an order for sale. So as I said, there's some context here. During the recent pandemic, we've all seen an uptick in instructions in this area. And the one piece of litigation we're going to focus on in particular is the Columbus and Vasco da Gama litigation, which has given rise to 3 reported judgments so far and possibly and counting. So Steph, do you want to just give us a pot summary of that, and then we'll start looking at some of the individual creditors?
Yeah, happy to, Paul. Columbus and Vasco da Gama are cruise ships, and there's obviously particular problems with cruise ships at the moment because nobody's doing any cruises. It's a very hard time for the entire industry. Often they've been laid up at home ports in the UK, so they are sitting there at risk in terms of the Admiralty Court's jurisdiction in terms of arrest and sale. So there are the 3 reported judgments in the Columbus and the Vasco da Gama. If I just give some of the background to that, those ships were laid up last year at Tilbury Port because of the pandemic, and then a few months later their operators went into administration. So the vessels were effectively abandoned. They were then arrested and have now been sold by the Admiralty Marshal, and the entire proceeds are paid into court. So I think it's fair to say that there are a lot of claims against these vessels. Yeah. So as Paul says...
sorry.
No, sorry.
Well, all being case managed together now as well. So
yes. Yes. So hopefully that will streamline the process. But yes, a lot of claims. So far, 3 judgments. We'll call them Vasco da Gama 1, 2, and 3. So Vasco da Gama 1 is about port dues. Vasco da Gama 2 is about a bunker supplier's claim, and Vasco da Gama 3 is about jurisdictional and timing issues in the context of a travel agent's claim for crew transport costs, but it's about when your claim needs to be brought. We'll discuss all of these later on. I mean, yes, I echo what Paul says. This is so far. I wouldn't be surprised if there's further judgments in due course.
Further reported decisions, exactly. Okay, so the first group of types of claim I think that we should look at, and often, almost always, one of the first things that people need to think about is the position of the crew. So Emmet has, I think an awful lot of experience of working on crew claims. Emmet and I share a room in Chambers, or did for a while, and Emmet seems to be always engaged on behalf of the crew. So Emmet, do you want to talk us through the crew position?
Yeah, so crew tend to be in a strong position in Admiralty claims in REM, and I think there are both legal reasons and practical reasons for that. So first of all, crew wage claims rank high in the order of priorities when it comes to distributing the funds after any court-ordered sale of the ship. So they rank above, for example, both the claims of mortgagees, so of any bank with a ship mortgage, and the claims of any suppliers to the ship. So, for example, bunker suppliers. Bound to happen. So the second thing is, more broadly, leaving aside their legal priority, is that the Admiralty Court in practice, the Admiralty judge, will be concerned to ensure that the crew's position is taken into account, and as far as possible, they're dealt with fairly and in a sensible manner. So in the last downturn, I acted for the master and crew of several vessels which were sold by order of the Admiralty Court. And I remember that I often used to quote the words of David Steele, who was a Admiralty judge in the early 2000s, who said in a case called the Rutte that the interests of mariners are high in the concerns of the Admiralty Court. Lord Stowell was prone to describe their lien as sacred. So that'll give you a flavour of the fact that judges in practice are quite keen to ensure that there is some plan put in place for the payment of the crew wages and for the repatriation of the crew. And I remember in one case, Mr. Justice Gross made clear that he wouldn't have made the order for sale if that aspect of things hadn't been satisfactorily sorted out before all the parties came into court seeking the order. Now, payment of wages and repatriation were routinely quite a big problem in litigation, say 15, 20 years ago, because in practice it often meant one of the creditors having to step in effectively to pay those expenses up front, but subject to the court making an order effectively subrogating those payments to ensure that they had the same high priority as if the claims were being brought by the crew themselves.
Yeah, because if there was no order, then you can't just step in and repatriate the crew. You get no proper priority at that point. Is that correct?
Yeah. So if your claim is simply for reimbursement, you won't necessarily have the same priority, because it's no longer a crew wages claim. It would be, or at least might well be, regarded as a claim of a different nature that wouldn't be entitled to the same high priority. So certainly if you were in that position and looking to step in to pay some wages or to meet some repatriation expenses, you certainly would be very well advised to get a court order first, ensuring that you're subrogated and thereby sort of preserving this high priority of the crew wages claims. But I think that this came up to some extent in the Vasco da Gama litigation recently, and the problem it's not completely gone away, but I think there's a new blue card system that's been put in place that has sort of made things a bit better. I wasn't directly involved in that aspect of the Vasco da Gama case myself, so I don't know. I
think that's Steph. I think Steph was on for the club looking at the crew. You basically, in the previous downturn, one of the issues you often had was the crew don't want to leave the vessel and don't want to give up their lien, give up their rights until they've been paid. And you might be looking to, as a creditor, looking to put a different crew on board and just change out the crew. The Vasco da Gama and in other cases, the issue that really come up has been that of repatriation, because maybe you've crew that want to go back to their home jurisdiction where we've got lockdowns all over the world. And yeah, Steph, I think you were on, I don't think this formed part of any of the reported decisions, but I think you've got some orders. Is that right?
Yeah, I mean, the background to this is that there's a Maritime Labour Convention, which is probably not something that shipping lawyers look at every day, but it's an international convention about crew rights. It's about lots of different things. But one of the amendments a few years ago was to provide for a blue card system where you as a ship owner have to have compulsory security in place to cover crew abandonment. So if you abandon your crew on board the vessel, there's security in place to pay the outstanding wages and deal with repatriation, etc. So you get this blue card on board the vessel and it tells you who the security provider is, etc. And usually in my experience, it's a P&I club, although I don't think it has to be that way. So if the vessel is abandoned, the security provider has to pay up to 4 months outstanding wages, repatriate the crew free of charge, and maintain the crew on board the vessel pending repatriation, which means providing things like food and water, medical treatment, fuel for domestic purposes, that sort of thing. So that's the scheme. But as we've been discussing, if you are a security provider in this position, what you do is, before you start making all these payments, you are well advised, certainly, to go to the court, get an order subrogating you to the crew rights, and therefore, hopefully, to carry on the appropriate priority level.
Okay, so now before we leave the crew, we've got a question on the Q&A, which pertains to crew. So let's look at this one. Mr. Coldrick mentioned the high ranking of crew claims in this jurisdiction, but under Portuguese jurisdiction, with respect to ships on the Madeira International Registry, crew ranges claims are much lower in ranking. Which ranking would prevail if a Madeira registered ship was arrested in England and Wales?
The English court regards the priority, the ranking, as a matter for the lex fori, so for the local court. So it's commonly the case that you'll have all sorts of different interests, international interests involved, and different sorts of claims originally arising in different jurisdictions. And it will even be the case, so obviously, that, for example, a ship mortgage will not necessarily be an English law mortgage. The ship may well be registered somewhere else. But in an approach that, as I understand it, broadly affects the practice internationally, if the ship is arrested in England and sold in England, well then it will be the English ranking of priorities that will apply. Now, I suppose it's also fair to say that ranking is not absolutely set in stone. Ultimately, the court does retain a discretion, but certainly the starting point will be that the usual English ranking will apply. And so those claims that are recognised in England as attracting a maritime lien properly so called, so that would be just crew wages claims of anyone who's had property that's damaged by the ship. And as Ben has already mentioned, salvage claims would have this particularly high priority. I'm sure we're going to go on and talk about the port as well. They also have a sort of special, almost super priority. But in England, those would be the top ranking claims.
Okay, yeah, let's look at the port next. I mean, that's kind of an issue that you see from time to time in other areas. So parties with contractual claims against vessels might have, well, my contract is governed by a particular law, and then I mean, you've seen this in bunker supply contracts, for example. Under the contractual terms you get, it is agreed between these parties that in the event of an arrest anywhere in the world, this claim will have the following priority, and that's sort of an issue that I think probably hasn't arisen yet in terms of what the status of a clause like that might be. Should we move on to look at the position of the port next, which is, I think, Steph, you called it the Vasco da Gama #1. I think it's only #1 because that was the first judgment to be reported of the trilogy. But this is Vasco da Gama #1, dealt with the super priority of the port.
Yes, yeah, it did. I think before we get into the facts of that decision, it's probably good to just do some background. The problem here is that the port claims, in practical terms, they fall outside the usual priorities regime. So ports have statutory rights to detain the vessel and even sell it until their dues are paid. So, and the cases have assumed that the ports can detain a vessel even if under arrest or subject to a sale order by the Admiralty Court. I mean, there's debate on that, but that's what is assumed. So if the port wants to be paid...
That was sort of almost challenged in the Vasco da Gama at an early stage, but that challenge didn't come to anything in the end.
No, I mean, yes, I'll explain what was nearly challenged in the Vasco da Gama, a bit later, but you're right. The cases here are operating on an assumption rather than a proposition that's been tested properly. So if the port wants to be paid on the current state of the law and it doesn't need to get rid of the vessel, which sometimes it might, in theory, it can sit on its hands and just detain the vessel while the fees mount up. And if you're another creditor, you can get into a little bit of an impasse. So what tends to happen in practical terms is that another creditor with an in rem claim will arrest the vessel, they apply for a sale order, and they also apply for a Queen of the South order, which is the name of the sort of leading case. Now, under a Queen of the South order, the port undertake not to exercise their rights to detain the vessel, and in exchange, the court then orders that the port's charges are payable by the Admiralty Marshal as an Admiralty Marshal expense. Now, Admiralty Marshal's expenses are paid first out of the proceeds of sale. So this order allows the vessel to be sold by the court and she can sail away, but the port gets paid before any other creditors, even creditors with maritime liens like the crew. So in this way, the port can use their sort of statutory detention rights to get a super priority, as Emmet sort of called it. But the Queen of the South order is a sort of procedural compromise, really. It's to break the deadlock. So in Vasco da Gama, they did make a Queen of the South order. There was a suggestion that some people might have questioned the assumption that the port could detain the vessel as against the court, or as against the Admiralty Marshal and prevent a court sale. But the problem is when you're in a situation where you need the vessel to be sold quickly and you know that claims are mounting up and you don't know whether the vessel's condition is deteriorating, etc., you haven't got time as a creditor to go to the Supreme Court and argue this out, So in the end, that sort of didn't really go anywhere. But in an appropriate case, that issue was still open and may be argued. So in Vasco da Gama, Queen of the South order made and the vessel sold. There's then a dispute about the amount of fees that the port could charge, because early on in the pandemic, the port had agreed with the operators that the vessels could be laid up at a rate of £3,000 per week per vessel. Now, when the operators go into administration, the port served notice saying that the vessels are going to go onto the tariff rate. And the tariff rates were around 30 times larger. They were around £90,000 per vessel per week. Unsurprisingly, other creditors raised their eyebrows at that point and weren't happy with that. So the Vasco da Gama one is about this issue. Are you allowed to hike your rates as a port in this manner? And are you allowed to recover all of those fees as an Admiralty Marshal's expense? And in the end, it turned upon the fact that there was a contractual term between the port and the operators saying that the port were entitled to vary their charges on reasonable notice. And the court held that contractually they were entitled to do this. You could see it's almost through gritted teeth. The court is saying, we're uncomfortable with this, but having looked at the statutory framework and having looked at the contract, there's no power in the court to say that they cannot charge, they cannot increase the fees in this way.
It is, isn't it? The judgment is almost through gritted teeth. It's a sort of this court has no jurisdiction to moderate these charges on the facts of this case. So might have another situation where, for example, the contract was that in the event of an insolvency, that's a material breach, terminate for a termination event, and following material breach, the charges payable on breach will revert to the published tariff rates, and then you might have the penalty jurisdiction potentially kicking in, subject to proof of the charges being out of all proportion to the port's legitimate enforcement interest. I don't know. One sort of senses that it was a conclusion in the judgment that there is no scope for us to moderate these charges here, so almost gratuitous, as you say, that's the outcome of that.
Yeah, I agree. And I think, that clause wasn't a penalty clause, and I understand why. But on different facts, given that they went through this contractual analysis, you could potentially, depending on how the clause is worded, you could argue about penalty clauses. If the clause also is triggered by insolvency, for instance, you might have problems under insolvency law, because usually if you have a contractual term which says this contract is terminated when the counterparty goes into insolvency, or provides for different rates on insolvency or something like that, you're potentially, that term is invalid under the Section 233B of the Insolvency Act, 1986, which they've actually amended during the pandemic. So,
why was that not decisive in the case then?
I believe because this legislation didn't apply in Columbus Vasco da Gama, because the bareboat charterers, who are technically the contracting party with the port, are not in insolvency, or there's no evidence that they are. So the operators are in insolvency proceedings, but they were not the contracting party. So
you get some Q&As. I think we've dealt with this one. Was the status of the clause as a possible penalty argued and decided? And so the answer is no, because it wasn't a sum payable on breach, but rather the contract remains on foot, albeit with a right to vary the rate on reasonable notice. So that's possibly a point that's left open for another case.
Yeah, and I think also, to be fair to the port, I mean, while the rate was very high, it was still its published tariff rate.
Yeah.
I think in other circumstances you could see perhaps more scope for a challenge if a rate that was some sort of penal rate or just higher rate than is usual was being applied. And particularly in circumstances where you have to bear in mind that the vessel will often be also sort of under detention by the port, pursuant to its statutory powers. So potentially you have a situation where the port is not letting the vessel go, and yet these very, very high charges are mounting up. So that's certainly the potential there for arguments from coming at this from different angles, including, I mean, perhaps it would take an extreme case, but including possibly an abuse of that statutory power of detention. Is what's going on here not really a sort of reasonable exercise of those powers, but the powers being used for an ulterior motive. But I think in usually speaking, ports are often quite pragmatic, and will be willing to move things along, so long as people engage with them at an early stage.
Yeah, one of the issues you're going to get, I mean, a common issue in any penalty clause argument is then people then look to the market and see what everyone else is doing. So you might have this great big body of evidence that this is in line with the charges being imposed by all the other ports. You have to go to their published tariffs and see that that's the position.
Yeah.
So you might sort of face that difficulty. I think what I think we should do next is move on and look at the position of jurisdiction and timing, which is actually the Vasco da Gama number 3 in time, because the judgment was reported sort of slightly after Vasco da Gama number 2, but I argued Vasco da Gama number 2 and Ben argued Vasco da Gama number 3. So why don't we look at timing? I think, I mean, the learning points so far are, you've got to deal with the crew. You've got to make provision in your sale order for the crew. So you bring your arrest proceedings, and at an early stage engage, how are we going to get an order for sale which satisfies the court's desire to see that the crew are dealt with, unlike perhaps the position in Portugal, as we've been hearing on the Q&A. You've got to deal with the port because their charges are going to be racking up. They're going to be reluctant to relinquish their statutory rights unless they're dealt with. And you've got quite a robust judgment of the Admiralty Court at the moment saying, well, sorry, but if the contract is put together in this particular way with the sums not being payable on breach, well, then we've no power to moderate, at least in the ordinary case, absent any sort of abuse of power or UCTA type decision or going off to the Supreme Court on the Queen of the South root and branch. But the next, so that's where we got to so far. The next thing I think we should look at then is the issue of timing, because in addition to these super priority claimants, you'll have a whole load of claimants who have in rem claims, perhaps bunker suppliers of spares, and so on and so forth, all around the world who won't have liens. They won't be sort of saying, we're holding on to this vessel, we're not relinquishing our rights until we're dealt with. And they might learn at some stage through, maybe quite late, that the vessel's been ordered to be appraised and sold. Possibly even when the sale goes through, you get the order is that the vessel's appraised, sold. The marshal advertises the sale. The prices are paid into court, and there's an advertisement regime whereby parties hear about this and get to submit their claims at that stage, or are invited to submit their claims against the proceeds of sale. And so that inevitably brings up questions of timing. You know, do I have to go early? Can I wait until the sale order, until I'm directed to submit a claim against the proceeds of sale? And that's really the set of issues that Ben was grappling with in Vasco da Gama number 3. So I think let's go to you, Ben, next and have a look at that one.
Yeah, as you say, and the key issue in this case was when can you bring the claim and when is too late. And the issue from which this emerges is Section 21 of the Senior Courts Act 1981, which sets out the jurisdiction of the Admiralty Court and the requirements jurisdictionally for bringing an in rem claim. And there are two requirements under Section 21(4). The first is that the person who would be liable on your claim, if it were brought in personam, must be the owner or charter of the vessel at the time when the cause of action arose. And the second requirement is that when you bring the claim, that same person is either the beneficial owner of the vessel or the charter of the vessel under a demise charter. And it's this second requirement that was really the key focus in the Aspida travel case. This was a claim by travel agents, and there were two jurisdictional objections which were brought. The first was that before you brought your claim, the demise charters were terminated by the owners, by the issue of a notice, and therefore the person who would be liable was no longer the demise charter at the time when you brought the claim, and there's no jurisdiction. And the second issue was to say that this claim was brought after the vessel had been sold by the court, and therefore, similarly, demise charters could no longer be the charter for the vessel once it had been sold. And for that reason, there was also no jurisdiction. And the first issue, termination of the charter by owners, was quite a factual issue in the end. It was, what was the effect of the notice of termination that had been served? And we were arguing that there were certain notice requirements under the contract. There had to be reasonable notice, there had to be 30 days notice, etc. And ultimately the registrar decided that the notices were instead effective immediately to terminate the demise charters at common law. And on that basis, he found that the demise charters had ended by the time the claims were brought, and there was no jurisdiction to hear the claims. But the second issue, which was ultimately left undecided in the case, was whether, if the charters had not been terminated, whether a judicial sale, a sale by the court, would operate to as the point at which no further claims could be brought. in respect of demised charterers. And the issue is quite simple in respect of owners, in the sense that a judicial sale will not operate to bar further claims against owners. And that's well established as a principle of Admiralty law. And it was most recently held in the Sanko Mineral, which is to say that even after a judicial sale, owners of the vessel will be considered to be owners of the proceeds of sale, and therefore claimants can bring claims against, will still have the jurisdiction of the Admiralty Court regardless. And the question in this case was really whether the 1981 Act extended that same regime, that same principle that a claim can be brought even after judicial sale in respect of demised charters of the vessel, extended the principle from the well-known example of the owners, whether the same principle would apply, or whether on a literal reading of the Act, such claims would be barred. But the issue was left open for another day. I don't know if any of you have any opinions on that.
I mean, on the question about, I wasn't involved in this aspect of the matter, so this is very much just a quick view. But I mean, I think I'm sure the court would be very strongly disinclined to treat demised charterers differently to owners, unless they felt absolutely driven to do so by the wording of the section of the Act. Now, I suppose that said, the case law, the wording of the Act, it doesn't really deal with this point in a very satisfactory way, in the sense that is the owner. You can see that just about one could be the owner of the proceeds of sale, but one's hardly the demised charterer of the proceeds of sale. So one can see that there are sort of arguments there based on the wording of the section. But I would have thought that a judge would be very strongly inclined, if at all possible, to take a pragmatic view and not to start having different regimes for charterers.
Yeah, I tend to agree with that. For what it's worth. I mean, it seems to me that obviously the prudent thing to do, if you know about where the ship's movements and where the ship's going, is to get your claims in, or issue a caution against arrest, and make sure you get your claim in early and get it issued against the vessel before the bareboat charter is terminated or there's a change in ownership. But the reality, the practical reality is, I mean, we're going to come on and look at bunker suppliers next. The practical reality for a lot of parties, well, we've supplied bunkers in wherever, Singapore, Gibraltar, some bunkering station somewhere, on credit terms, 90-day credit terms, something like that. You might not find out until later in the process, once those orders for advertisement and sale come in. You might not find out until it's too late. So if it's right that the termination of the bareboat charter scuppers your claim, that could lead to some quite difficult distinctions, I think, and as you say, drawing fine lines between, well, was it bareboat chartered or was it outright owned? So I tend to agree with that. I don't know, any other views before we move on to Vasco da Gama number 2 and the position of bunker suppliers? Let's move on. Steph, go on.
No, I was just going to briefly say, yeah, I agree. I mean, if you're a bunker supplier, as you say, you've supplied these bunkers and you've done it on credit terms, you don't know when the owner is going to serve notice terminating the bareboat charter. You don't know if the bareboat charter is paying higher or not, But I think the lesson to learn is get your claim in as early as you can, I guess.
And another panelist suggests you could shift your vessel from, not panelist, viewer participating says you could always shift your vessel from England and Wales to Northern Ireland. For the bareboat arrest is available, although you have to pay off the port first, of course. If they're, Vasco made it quite interesting was they were home ported in Tilbury, and obviously a lot of merchant vessels are not going to be home ported here, but they were returned to their home ports and for various reasons the crewing's done out of English ports. Okay, let's look at the last in the trilogy of Vasco da Gama decisions, which concern the final group of creditors, which we're going to look at, which is bunker suppliers. They belong to a group of creditors known as necessary suppliers or necessarious men. who will have a maritime lien, so an in rem claims, and go against the vessel, not against the impecunious owners, if they can establish a claim in respect of goods or materials supplied to a ship for her operation or maintenance. That's under section 22M of the Senior Courts Act. So you've got quite wide wording, any claim in respect of goods or materials supplied, but then slightly narrower wording for her operation or maintenance. And there were quite a few previous decisions in which it was established that that test has to be satisfied in respect of each individual claim that you're bringing, at least where you have a multiple supply contract. So in the Edinburgh Castle and a case in Hong Kong called the Oriental Dragon, where you had agents supplying crew services, spares, all manner of other things, web design for the for the advertising the vessel's line, I think. So a whole number of different things. And so yes, you have to establish that the test is satisfied for each one. The unresolved point under Vasco da Gama number 2 is whether that test had to be satisfied for each head of claim under a bunker supply contract. So the argument was, well, in that scenario where the bunkers are supplied on, say, 90-day credit terms, against what might be considered a high or exorbitant but non-penal rate of interest, with things like indemnities for solicitors' costs and administrative fees, non-penal admin fees, things like that. The argument was that those should all rank as in personam claims and should be redirected against the operators, because those were basically a function of that contractual bargain and nothing to do with the delivery of bunkers to the ship. You could always go just at the bunker base price and not avail yourself of those credit terms. So it was argued that those were purely financial claims. And you can see, if you're focusing on 4, well, are these really things that were incurred for the operation or maintenance of the ship? Whereas if you're looking at the words in respect of, is it broadly a claim in respect of the underlying bunker supply, with the underlying bunker supply, of course, being something that's obviously for the operation of the ship. And what the court held was that you look in a single supply case, so it's right in a multiple supply case, you look at each supply separately. Is it web design fees? Is it the bunkers? But in a single supply case, the court declined to slice and dice and pick and choose between the aspects of the package of contractual remuneration provisions that some of the other creditors perhaps didn't like. So once you're through the gateway by reference to the underlying supply, then all those ancillary claims can be brought in rem as well. So a little bit like in the Vasco da Gama number 1 with the port, here you've got another strong decision of the Admiralty Court saying we have no jurisdiction to moderate this claim. We don't see this as a matter of contracts between you and the in personam defendant. We see this as all part and parcel of the in rem claim, and we've no jurisdiction to moderate sort of exorbitant but non-penal rates of interest. Those are all claimable against the ship. So I think the point that then is left open is perhaps the possible difficulties which you might have with apportionment in a situation where you've supplied a suite of necessaries and non-necessaries, and then you've got one running account and an indemnity for solicitors' costs and things like that, and perhaps a contractual interest rate. Well, do we then apportion so that we have to try and work out which parts of the claim are referable to the necessaries or not? But again, we've got a very strong message coming out that as far as the Admiralty Court is concerned, it's got no jurisdiction to moderate that contractual bargain once it's through the in rem gateway. I wondered, I might just read out from the Q&A. We've got something related to this. So arrest in rem is the ultimate security for mortgage financiers, relevant when vessels might disappear into the horizon. Today, it's being used as waterboarding strategy by credit funds seeking to create pressure on owners and exit loans by acceleration. Is UK law concerned about this defensive measure as being abused in an offensive manner? So I think what's being said is, well, is the court live to this and to the notion that, well, perhaps these port charges might be exorbitantly high, and the ports are saying we won't relinquish our lien unless they're paid, or perhaps the bunker suppliers' interest provisions might be sort of eye-watering monthly interest, and the bunker suppliers are saying, well, no, we want the whole lot against the vessel. We're not prepared to hive off bits that are referable to the underlying supply and bits that are more to do with a credit recovery strategy. So, I mean, for me, I think the clear message we're getting, at least at the stage of is it an in rem claim, is, well, once you're in, it's all in, subject to penalties, which we discussed earlier. So I think that's probably the position. Does anyone else?
There's a further point there, which is as to the abuse of the arrest process. And as I understand it, the position is that if the process is being used in bad faith and doesn't have any commercial reason for it, then there might be some liability of the arrestor. But absent that, there generally isn't liability of the arrestor.
You might have an issue when you get to priorities later, of course.
Yeah.
All I was going to add is that insofar as the question is also getting at the position of arrest effectively being abused by banks, I think the reality in terms of the approach in England, I know the commercial court is often accused of being rather pro-bank, but I think that fundamentally the position in the commercial court or the Admiralty Court is that if the terms of the relevant mortgage entitle something, so there is a provision that if installments on a loan aren't paid in time, then the entire loan is accelerated and immediately due. Well, those terms will be given effect to simply because they're terms of the contract. So I can certainly see that from a ship owner's perspective, it might be regarded, perhaps rightly, as rather draconian if, because of say one or two late installments, a credit fund or some other financier is declaring events of default, arresting ships and seeking to have them sold and just get out early. I mean, the reality is that if the terms of the relevant finance instrument allow that, well, inevitably that's going to be that's going to be enforced, and regrettably, well, I mean, it depends on your perspective. I mean, at the end of the day, it's a commercial agreement, and if you signed up to particular terms that allow for acceleration, etc., well, the reality is that those terms will be enforced.
I think we've just got time for a couple more questions. So I've got them streaming in. So where do pollution's claims rank? Brackets, naive question, sorry. No, there are no stupid questions. It's a good question. Where do pollution claims rank? And second, some jurisdictions do not recognize the cleansing effect of a judicial sale in a foreign jurisdiction. UNCITRAL is working on a draft convention on the recognition on jurisdiction on judicial sales. How do you see that problem being tackled? So that's a question about once the Admiralty Court's ordered the marshal to appraise and sell the vessel, then the purchaser takes clean title. So who wants to have a go at either of those questions? Anybody? Which one? Which would be Ben?
About pollution. I think that pollution would rank as a maritime lien in terms of damage done by a ship. And that category is quite narrow in the sense that it must be physical damage done by the ship as a result of sort of something physically done by the crew of the ship or the vessel. But I expect, without seeing the exact example of pollution that we're talking about, that it might rank there and therefore actually have quite a high priority.
I would say, from my experience, pollution claims are going to have a high priority. I would agree with that. And then anybody on the cleansing effect of the judicial sale, whether there's a need for an international uniformity of approach and a convention to recognise the clean title of the purchaser, whichever jurisdiction has ordered the sale of the vessel. Any takers? I mean, it can only be a good thing.
Yeah, I mean, this was part of the issue in my case, which was that the quid pro quo is that on judicial sale, claims can no longer be brought against the ship, but claims are transferred instead to the proceeds. And certainly that's the position in England and Wales. And agree with Paul that it can only be a good thing. However, I would probably say that certainly experienced commercial parties looking at a ship that is about to be judicially sold, will probably do their due diligence in terms of what effect that will have and whether they'll be protected in all sorts of jurisdictions that they want the ship to operate in. And therefore it's probably factored into the price to an extent.
And one issue might be, depending on the jurisdiction that's going to order the sale of the vessel, whether there are sort of concerns about the quality of justice, if you like, in place of arrest and sale, and the quid pro quo is that, well, we're all signing up to this. You recognise my order for sale, I'll have to recognise yours. All right, now Emmet, sorry, go on.
No, I was just going to say that ultimately it's all about getting people to sign up to it. So a convention would be a very good idea. But if there are sort of problem jurisdictions that aren't recognising legitimate judge-ordered sales in places where the ship has actually been under arrest and the whole of the proceeds of the sale of the ship have been distributed, well, then the problem is that those countries may well not be the countries that are inclined to sign up to sensible conventions in the first place. So definitely a good idea, but whether it'll solve the problem completely, I'd be a bit more skeptical about.
Yeah, I think it probably also highlights one of the aspects of this Admiralty jurisdiction, which is that due to the arrest convention, there's quite a high degree of uniformity about the types of claims on the basis of which you can arrest a vessel. But the rest is quite variable between all the jurisdictions. And, we've already mentioned the example of the priorities of crew in Portugal, but also clearly in respect of judicial sale.
Okay, now I think that draws us to a close. So thank you very much to everybody for watching. I hope you found it informative and enjoyable. I hope you felt that those of you who put a question to us got at least some sort of an answer. Just time for a quick plug. Next Quadcast coming up is on Thursday, where the regular Quadcast team will be taking a look at the law of bribery. And then the next Quadcast Shipping Special will be coming out after Easter in April. And our marketing department will be sending you lots and lots of flyers about that. So thank you very much. And hope that was an enjoyable seminar for everybody.